I put a question that the Uganda People's Defense Forces Amendment Bill 2025 be read a third time and do pass. Those in favor say the court.
Order, Madam Speaker.
The ayes have it.
In late May 2025, Parliament passed the Uganda People's Defense Forces Amendment Bill 2025 with an element of trying civilians in the court-martial under specified circumstances. The legislation establishes military courts categorized as unit, division and general court-martial.
The members of the UPDF court-martial must be independent and impartial. They told us how they believe the independence and impartiality should be set out.
This was after the January 31, 2025 Supreme Court ruling on the Constitutional Appeal number 2 of the Attorney General versus Michael Kabaziguruka. The Speaker of Parliament, Annita, while in Soroti District at an NRM function, said the UPDF bill has been assented to by the President.
There was a bill which was brought to Parliament on UPDF. The UPDF bill is going act now, which because it has been assented, is going to help us people in Teso. With these people who come with the guns when they are not supposed to be having guns. It is also because we have so many veterans in the area. It is going to help the veterans in terms of their welfare, in terms of medical.
In an interview with the main contender of the trial of civilians in the court-martial, Michael Kabaziguruka describes Article 210 of the Constitution, which he says does not call for establishment of the court-martial.
210A is to the effect that Parliament should regulate the structures and organs of the UPDF. In B, Parliament should handle the recruitment, promotion, discipline, and removal of members of the Uganda People's Defense Forces. The Constitution is clear. Recruitment, promotion, discipline, and removal of members of the Uganda People's Defense Forces. And in C, it says terms and conditions of service. D, it says deployment of troops outside Uganda. Nowhere under that article does Parliament get the mandate to establish a court of law.
Whereas the new legislation is clear on the exceptional circumstances under which civilians can be tried under the court-martial, the critics think otherwise. Immediately after the ruling, the Attorney General was quick to advise, and the advice was maintained even up to the passing of the UPDF Amendment Bill, that the Supreme Court did not nullify the establishment of the GCM, but rather the trial of civilians. So it looks like in your submission you're faulting Parliament, but how about the Attorney General?
You see, the Attorney General, unfortunately in this matter, has been found wanting, because the ruling was very clear that it affected both civilians as well as... Now, if the Supreme Court says that this establishment is not competent enough, that its composition, that the qualification of its members is unconstitutional, then how can it exist? If someone says that it is not capable of giving anyone a fair hearing under the way it is composed, how can it then be in existence?
The Speaker of Parliament says the UPDF Amendment Bill has been assented to, but Michael Kabaziguruka wants to appeal.
We know, for example, recently, that there were some people who were convicted of murdering the late Joan Kagezi. Now, these people did not use stones, neither did they use spears, but they used guns. And those people were tried before the civil courts, found guilty and convicted. There are aspects of the bill that I agree with, but the part relating to the GCM, I am fully opposed to it, and I will be going back to the courts of law to challenge it again.
Meanwhile, despite the Speaker's revelation, State House has not released information concerning the move. Daniel Mugoya, UBC News.
Abutengo.